Can an automobile insurance company be held in bad faith when they fail to pay a claim when the law requires them to do so? That was the question in the case of the frivolous denial. In this case, Bonnie was severely injured in an automobile accident while driving a company vehicle to a patient's home to perform her nursing duties. She incurred life-threatening injuries and incurred over $380,000 in medical bills. She filed a workers' compensation claim, which was denied in January and February of 2006. Based on the denial, Bonnie then made a claim for medical benefits under her automobile policy that provided $100,000 coverage for medical bills incurred in an accident. South Dakota law requires insurers covering bodily injury to pay medical benefits when workers' compensation denies coverage for medical bill claims. The automobile insurance company started to investigate the claim throughout the spring of 2006. In June of 2006, the medical bills continued to grow and still no payment was made. Further, despite Bonnie's continued request, medical bills remain unpaid throughout 2006 and in all of 2007. In December of 2007, Bonnie sued her automobile insurance company for breach of her insurance contract and for bad faith for denying her the medical benefits despite the fact workers' compensation had denied her claim. The court dismissed her claim and Bonnie appealed. How would you decide this case? Can an automobile insurance company be held in bad faith when they fail to pay a claim for medical bills for over 2 years when the law requires them to do so? We'll be right back in a moment to answer this question. Can an automobile insurance company be held in bad faith when they fail to pay a claim for medical bills for over 2 years when the law requires them to do so? Yes, said the South Dakota Supreme Court. South Dakota law clearly provides that when workers' compensation is denied, the injury is presumed to be non-work related for other insurance purposes, and any other insurer covering bodily injury shall pay according to the policy provisions. The intent of the law is to protect people like Bonnie who need treatment for their injuries while the insurers resolve coverage disputes. The court stated, "The language of the statute is plain, unambiguous, and not susceptible to debate." The insurer's argument that the issue was fairly debatable was rejected. The company's failure to provide coverage under its contract within the plain meaning of the law can violate their duty to deal in good faith. The lower court was reversed, allowing Bonnie to have her day in court. Remember, it's a matter of law.